All right, to get this party started, I want to introduce you to presenter Kathy Schofield. Kathy has been practicing in trust and estate law for many years. She has a lot of experience with financial elder abuse litigation. She is well respected and well known within the community here in Contra Costa County. She's been the president of the board of directors for Contra Costa County Bar Association. She's currently the head of our elder law section for the Bar Association, and she's someone who I always am excited to get on a case with because I know that she will deal ethically and kindly and efficiently with all parties and counsel.
Wow, thank you. I'm going to go through our panelists and then hand over to Lara, who also has a wonderful reputation around town. I'll start with, on my right, the Honorable Ruben Sundeen. He was appointed to the Alameda County Superior Court in 2022 and is now doing criminal misdemeanors. But the reason why he's here today is his extensive background. First as a commissioner for many years. 2019, it was 2018, okay, as a commissioner in Alameda County. And before that, as a practicing lawyer in the conservatorship and probate space. So thank you so much for being here. I appreciate your presence here. And then again to my right is Christina Nalchajian. I've just met her. She has been practicing in the conservatorship, probate, trust, and litigation space since 1994. She currently has her own solo practice and has a great background in the guardian ad litem arena, which is one of the reasons why she's here today. And by the way, Alameda County, in our perspective, has developed the area of guardianship, guardian ad litem and court appointed counsel in a way that is probably more advanced than Contra Costa. Their system has been in place, and they can touch on that, for many years. And I think in comparison, Contra Costa's came its way, which is why we lean heavily in Alameda County on this board. So the third person, who hopefully you all are familiar with, Scott Thomas. He is one of the court investigators in Contra Costa County. He's been there for 18 years.
18 years.
Yeah, and he's an attorney graduating from JFK Law School, so a local guy. Before he was a court investigator, he was a law enforcement officer and an attorney in this area of law as well. He, in the court investigator's office, I think he's the lead for the complex cases. Is that fair to say?
I wouldn't say I'm the lead, but I tend to get quite a few of them as more senior, and particularly any involving estates, complex estate planning, and then the partnerships and sessions because of my past practice.
He's going to do that.
Thank you.
Going to do that.
By the way, can people hear us okay? Because I'm not sure that the mics are on.
Speak up? Yeah, a little bit.
Okay. And then finally, Lara Heisler. She's one of the founding partners of her firm, Heisler and Rosenfeld. She's a trial attorney, has a focus on elder abuse, and has an extensive background at the Court Appointed Counsel, guardians ad litem, both in Contra Costa and in Alameda. And she's also a board member for the Conflicts Program, has been for 15 years. So there's a very accomplished panel here who can speak to this issue that I don't know about anybody else here, but for me, the interplay between court investigator, guardians ad litem, and court appointed counsel has become very confusing, and hopefully this will shed some light on what the issues are and how people are navigating them.
Yes. So, because this is an MCLE, we have a PowerPoint. And this is a very heavy PowerPoint because we wanted to give you a place where you could have all the statutes and law that you would want to refer to easily accessible. So this is part of your materials, and I'm going to zip through it because what I want to do is spend the most time today talking about how these laws apply. So we're going to, if I'm going too fast and I'm not reading anything, don't worry, you'll have it, and we'll talk about it more as we apply the law to our cases. So many of us, at least in Contra Costa, who've been practicing law in this area and who've been court appointed to represent conservatees, we had a way that we used to do it. We used to meet with our conservatee, and if our client clearly lacked capacity, we would tell the court something like, oh, my client wants to stay in their home where I walked in and the door was unlocked and they were wearing soiled clothes and their glasses had no lenses in them and their son was working on his meth lab at the kitchen table. And I think it's in their best interest to not leave their home. So we used to be able to kind of do that, a hybrid. Advocacy was tepid, and best interest was at the fore. But something changed. What changed? Well, it's our friend Brittany. Poor Brittany. She's gone through a lot. And in the wake of everything that happened with Britney Spears, who's the poster child for conservatorships gone wrong, the legislature and the bar, in its infinite wisdom, made sweeping changes to conservatorship and guardianship law to make it harder to establish and easier to terminate a conservatorship. So, the main changes that you need to be aware of now is if you are court appointed to represent a conservatee, your job is zealous advocacy for what the client says they want, period. And if you are court appointed, that's your job. If you have a client who may have capacity issues, but who hires you, and if the court approves you being retained, your duty is the same. Your duty is to advocate zealously for best interests, and clients now have the opportunity to select their own attorneys if they don't like the court-appointed attorneys. The other big thing is that we are focused on what the client wishes, not what we think is best, but what does the client wish. It used to be that appointing counsel for a conservatee was discretionary. Now it is mandated in a conservatorship case. And counsel has to be appointed in a proceeding to terminate, a proceeding to establish, a proceeding to remove a conservator, any of the major issues, a conservatee gets their own counsel. And if the conservatee hasn't hired their own counsel, it is very important that the court appoint an attorney, sometimes through the public defender's office, as we see in Solano County, sometimes through a panel, as we see here in Contra Costa County, and in Alameda County, of course, there's legal assistance for seniors that does a tremendous job representing seniors, and also they're a hybrid because they also use the public defender's office. Many of us have been lucky enough to work with the PD's office in Alameda. Another change to the law is that there are annual reviews. We're not just going to let conservatorships go on forever. The court has to look into it. We have to file reports. It's a real big change in the psychology of a conservatorship. There was a sense that once people were conserved, it was game over. In a petition to terminate a conservatorship, the conservator, after a year, would have to provide new evidence, clear and convincing evidence that the conservatorship is still necessary. So they're really trying to address the issue of people getting well, stabilizing, and still lacking agency. And that's why we're putting in all these safeguards. And There are a lot of training requirements for people who are going to be representing conservatees, which is excellent to have all of these rules of court that talk about the level of education that you have, because we can see in our practice those who are appointed by the court have knowledge and experience that can really help in their representation of a conservatee. And then sometimes we see when a conservatee brings in, their real estate attorney or their divorce attorney, it might make moving the case forward a little more challenging. So we are grateful to have education requirements for Court Appointed Counsel. This brings up some ethical issues because in California, if you're representing someone in an area of law as an attorney, you need to be reasonably competent in that area of law. So it's something to think about if you are aware that a conservatee has chosen an attorney who has absolutely no experience. Maybe you're the conservator. You might want to ring a bell saying that it might be good to have court-appointed counsel as well. Lawyer is to abide by a client's decisions in all aspects, and it is important to maintain client confidentiality. Now, this is important to think about in the context of providing zealous advocacy for a conservatee who lacks capacity, because you can't, if your client can't speak to you, or if your client can only speak nonsense to you, how do you convey that to the court as a zealous advocate if your client can say, no, I don't want to be conserved because the Martians will take me and, whatever they're saying, you have to be really careful because you need to maintain client confidentiality. And by saying my client can't express to me their preference, are you violating confidentiality? So there are all these ethical issues that you have to think about when it comes to representing an incapacitated person. And more on attorney-client privilege, which is in Evidence Code 952, and there are Contra Costa rules. In Contra Costa, if you want to represent conservatees, you need to be on the panel. And for guardians and litem, it's a little different. The court in Contra Costa has been asked multiple times by the conflicts program that has a rotating system of appointing attorneys for conservatees if they would like to have guardians ad litem appointed through that system. But as we sit here today, the court enjoys being able to select and matchmake who they're going to appoint as a guardian ad litem to a particular case. So you can have an opinion about that, good or bad, I don't know. I like getting the call, but I also don't like it when they call certain. So, that's how it goes. How long does court-appointed counsel serve? Until you don't. Until the conservatee passes or until you are affirmatively relieved as counsel. Keep that in mind. Money becomes an issue. Money's an issue. When we've got court-appointed counsel, guardian ad litem, conservator, maybe it's a family member conservator, but they're still represented by counsel. Maybe it's a fiduciary who's also getting paid, and then their attorney. We've got a lot of hands in the till, so it's important to be aware of getting court approval for fees and knowing what the scale is and what is appropriate to bill for who's doing what. And in Contra Costa, we have guidelines based on years of experience for attorneys, as you can see here. Okay, quick overview of guardian ad litem. I told you I was going to go fast. Am I going fast enough? Okay. All right, guardian ad litems. This is where it used to be really comfortable as a court-appointed attorney to advocate for best interests. For me, that was a much more comfortable place to be. It felt like when you're representing a child and you get to do sort of a hybrid of what the child wants by advising the court what the child wants and also making a case for what's best for the child. And I personally really enjoyed playing that role as conservatees counsel for many years. However, that's not the job anymore. That's not the job. The job is to advocate zealously for what the client wants, and it is someone else's job to advocate for best interests. And that can be a really difficult pill to swallow, but we have guardian ad litems, and we have mechanisms to get them appointed, and that's what we need to do. Because the guardian ad litem is the one who's going to fight for best interests. So when would that guardian ad litem be appointed? By the probate court, through a nomination or petition by one of the parties in the case, by the court's own motion, and we'll talk about who should do it versus who could do it as we go through the hypotheticals. What do you do when the incapacitated person objects to having a guardian ad litem? That's a tough one, and we see it come up because the act of having a guardian ad litem by operation of law is a piece of evidence that you lack capacity. And so if your client believes they have capacity, or if the conservatee believes they have capacity, then you will have court-appointed counsel fighting against the appointment of a guardian ad litem because it's a tacit admission of incapacity. So while on paper having both players seems like an easy fix, it can get a little dicey when you've got a very active court-appointed counsel fighting against anything that will make the client appear to be incapacitated. So the considerations that factor into seeking appointment of the guardian ad litem, I think that, at least in Contra Costa, I feel like if the judges see that there's an early cap deck that indicates that a conservatee has demonstrable capacity issues, and we have a court-appointed counsel advocating for something that is patently harmful to the conservatee, then the court will sua sponte appoint a guardian ad litem. And we'll talk in our hypos about when other players in a case might want to request a guardian ad litem. So when and why does someone with a temporary or general conservator need a guardian ad litem? I think that's the statutes give authority, but basically when there is a disconnect between what the client wants and what's in the best interest of the client, it's very helpful to have a guardian ad litem. And who chooses the guardian ad litem, as we touched on earlier, depends. I always like to try to pick my guardian ad litem and submit a petition to request a guardian ad litem, but it's a very contentious case. Anybody you suggest is going to be rejected out of hand. Alameda County has a nice system where they have a few attorneys. Not sure how you get on the list, but they have a list and they cycle through. And it just varies from county to county, just be aware. With all of these different roles, it's really important for everyone to stay in their lane. Because there can be a lot of stepping on toes when you have let's say you have a professional fiduciary who believes that their job is to look out for the conservator's best interest, or conservatee's best interest. And you have court-appointed counsel who's advocating for what the client wants. And then you have a GAL who is trying to advocate for best interest, but may be concerned that simply advocating for best interest will destroy a family dynamic to the point that it is no longer in the best interest of the conservatee. So there's a lot of balancing to do, and it's very helpful to have open lines of communication with all the various players. And now we get to the fun part, hypotheticals and case studies.
Hopefully everybody has a copy of the packet on the hypotheticals. I'm going to read through the first one. It's a page long, so bear with me. If you can't hear me, tell me. Hypothetical 1 is Gus and Gladys grandparents. Gladys Granny and her husband, Gus Grandpa, were aging in place at their Lafayette estate. Beautiful Dora lives in Southern California but is devoted to her grandparents and visits often. Gus was diagnosed with terminal brain cancer in 2019. Gus had a long illness, and Gladys was appointed as his conservator during the worst of the pandemic. Lisa Lawyer was his court-appointed counsel. Everyone agreed that a conservatorship was appropriate, as Gus was behaving erratically and would rebuke Gladys' efforts to help him as POA. Lisa Lawyer convinced Gus that a conservatorship was in his best interests. In 2021, Doris took Gladys Granny to a doctor's appointment, and Gladys was diagnosed with vascular dementia and mild cognitive impairment. The doctor suggested a neurological assessment for Gladys, then told her to quit smoking and lose weight. Gladys told Dora she would never see that quack again. Dora visits when she can, but Gus and Gladys needed in-home help. In 2021, Gus and Gladys hired minimum wage caregivers from Craigslist, Ashley Abe and her cousin Hunky Handyman. Ashley provided loving care to the couple, and Hunky did some odd jobs around the house. This arrangement lasted a year until Gus died in late 2022. Within 2 weeks of Gus's death, Hunky declared his love for Gladys, and he and Ashley moved in with Gladys. Gladys loves Hunky and has paid him $250,000 to fix up the house. Gladys loves Ashley also. Ashley helps Gladys with showering and other intimate care, does light housekeeping, and redirects Gladys when she awakens in the middle of the night. Gladys takes Ashley with her to the salon and out to lunch daily. Ashley is her best friend. When Dora, who was Gladys' POA and successor trustee, found out about what was happening, she successfully sought a temporary conservatorship of Gladys and temporary suspension of Gladys as trustee of the Grandparent Family Trust. Dora filed for an elder abuse restraining order against Hunky, and it was granted. However, Ashley still lives with Gladys and provides care in exchange for rent. Gladys and Ashley refuse to let Dora in the house, so Dora is struggling to get a capacity declaration. Gladys wants to disinherit Dora, and she has signed a deed granting the Lafayette house to Ashley. Gladys is furious at Dora and hired an experienced probate attorney, Alan Aggressive, to object to the conservatorship and trustee suspension. The court confirmed Alan as court-appointed counsel. The court appointed a guardian ad litem on its own motion. The court-appointed counsel filed a glowing capacity evaluation from Gladys' dermatologist. The court-appointed counsel objects to all medical exams and argues that Gladys is able to manage her affairs with a little help from Ashley. Dora is worried that at the next hearing, court-appointed counsel will be successful in arguing that Dora has presented no evidence of Gladys' incapacity and that the guardian ad litem should be dismissed. Dora has noticed Gladys' deposition, but it has been rescheduled several times due to medical issues. So this raises a whole lot of issues, and I'm going to just toss a couple of questions. We summarized some of them on the next page. This is actually a pretty, it has a bunch of stuff in there, but it's actually a pretty common scenario that we see, and it raises issues of whose lane is whose lane. So the first question is, so what now? Here we are. If you are a judge looking at this case, if you are court-appointed counsel, what is your role? What does the court investigator see? And I'm just going to start. And So what next question?
You can just do the whole thing.
So, as a judicial officer, I just pass it. I just wait for people to come to me. So, well, it starts off with a petition, right? Someone's got to file something. It doesn't have to file on its own, right?
Well, we have a temporary. So,
Yeah, well, we have a temporary and we have a GAL appointed by the court on its own motion. So I'm going to jump in on the GAL.
All right.
I mean, as Ms. Heisler made clear, the separation between court appointed counsel and GAL is obvious, right? So we're not going to wear either the hat of the zealous advocate or the hat of best interest of the proposed conservatee or conservatee. So if Judge Sundeen appoints me as GAL, first of all, as a GAL, I feel like I have the ability to jump in. I have no duty of confidentiality. I have no client. And I can just, I don't want to say run roughshod, but I can talk to anyone. I will call counsel and let them know I'd like to speak with their client if someone's represented. I've never had someone refuse to allow me to speak to somebody, because if they did, that would be a petition to the court, an ex parte petition real fast. So that's not arisen for me. It hasn't arisen for me. But once I'm on board, I can explore in a whole slew of areas and then draft a report to the court, letting the court know in my personal opinion, and with the caveat, and I put that in every report, that I am not a neuropsychologist, I am not an expert on capacity, but as opposed to court appointed counsel, I can report regarding any medical stuff I've reviewed. I can report that the proposed conservatee is nonverbal, or that I can report regarding appearance, condition. I can give the judge tools that they may need in order to move forward and provide a better picture to the judge that the person sitting in the robe on the bench does not have at that point.
Can I interject one thing?
Yeah.
You might be an expert on capacity, but that's a legal definition. Yeah, there are doctors out there who make the claim ultimately it's a legal finding, and you're a legal professional, so I think you're just as competent as anyone to say that this appears to be. I mean, I have to make the finding, but this appears to be a case of incapacity. So I think you're much of an expert as a medical professional. They don't know. And in fact, it goes to capacity, like the capacity declaration you said about finding incapacity. I think they're different. I think the capacity declaration talks about process, but for me it's more about judgment. I don't care what your process is. If you got good judgment, I'm hands off. I don't care. And so the capacity declaration is really about process, but I'm looking for judgment. That's more important. Can they self-advocate? Do they have judgment? If so, I step out of the way. I'm not there to prevent people from making mistakes. I do that all the time. Hourly basis, easily.
So let me just ask a question about the guardian. I'm sorry.
No.
The guardian ad litem's investigation. Do you see your role as going and talking to the doctors directly, or propounding discovery? And what do you expect that everybody is going to be sharing all the information honestly and straightforwardly? I'm thinking in particular, let's say there was a doctor evaluation that court appointed counsel had and knew that it was bad. Do you expect to get that report from them?
I would hope to. I wouldn't necessarily expect to. I know this touches on not wanting to get medical records. Usually what I tell somebody is, if I'm a GAL and there's medical stuff out there that maybe a person I don't have it, is, look, we can do this the easy way, or we can do this the hard way, Ultimately, if capacity is an issue, if medical records and capacity evaluations and things like that are going to, the truth will out, right? We're going to get those records. And do you want to spend 10 or 20 grand getting those records? Or do you want to just hand it over? Is my typically received what I've asked.
And let me follow up on that. I'm surprised that people fight with guardian ad litem. They should be your best friend. Because if you can get the guardian on your side, then you've got two people arguing for your case. And so I'm surprised some people do fight. But That's crazy.
I know.
Because guardian ad litem is basically, that's an arm of the court. You're a judicial officer, you're a quasi-judicial officer. You're subject to quasi-judicial immunity. Anyway, you're my eyes and ears.
So I will say this, I was trained by him, so. The other issue you touched on was discovery. Generally, as a GAL, I can and will get involved in discovery if I need to. Often I will actually inform the court of what's going on and ask for the court's authorization to embark on something. But there have been instances when I have objected to the depo of someone who allegedly lacks capacity to set parameters for that. I've had to deal with different discovery issues. I have, as a GAL, filed a petition for a conservatorship for a proposed conservatee with the court's authorization. So I think something to, yeah. So it's, I think it's I think as a GAL, what to keep in mind is if you think you are overstepping your bounds, go to the court and let the court know, ex parte, whatever you need to do, and say, this is what I think, or is in the best interest and I propose should happen. What do you think, Your Honor? You know, let me know what my parameters are.
So I have probably guardian ad litem like 30, 40 cases before I got appointed. Maybe 40, 50 is a lot. And I filed a few affirmative cases, but I've always got court approval first. And I was always very circumspect before going through and doing formal discovery because it's an expensive process. I would be like you had to do informal interviews and just bullfight my way through and talk to people. And if they didn't want to talk to me, like I said, I never understood that because I could be your best friend. I could be supporting your position. And that's sometimes the reason why people don't want to talk to you. Trying to hide things.
What would you guys say is the most important information that a guardian ad litem can put in a report, and how important is it to do a written report?
I would encourage a written report in every case because it's a record, black and white. And I think that we all have instincts that we rely upon, but putting it in paper, black and white, forces you to really articulate what you're seeing, what you're thinking. It's a little more onerous than just a formal report, but it establishes a record. So, for example, as you know, judges move around. The next judicial officer can see it, doesn't have to, because no one really pulls up the transcripts unless you really want to do it. But I would encourage one every time. What I used to do too is I'd do a list of all the things I reviewed. These are the documents I reviewed, these are the people I talked to, and then these are my findings, if you will, that I had as a director of election, and that was really helpful. Listen, we got different people telling me different stories. I'm looking for somewhere to hang my hat. And just an FYI, I always hang my hat on the undisputed facts here. And then what inferences we can make from those undisputed facts. That's starting.
I think too that as a GAL, once you are involved, you talk to enough people, and let's say for instance that capacity is an issue. It's a gray area. You're not sure about the conservatee's judgment, even as a GAL, and the parties are fighting about that. I've had, in a couple cases, the ability to sort of get the parties to come to an agreement. Well, why don't we see if we can agree, let's first agree that maybe a neuropsych eval should happen, and if so, how can we get that done? And come in as a GAL, whereas as a court appointed counsel, if your client does not want an evaluation, that's what you're reporting to the court. I can come in and say, look, maybe we could get the judge and kind of to do a 7:30 eval, or have some flexibility here to make something happen that isn't happening without having to spend 20 or 30 grand litigating it. And maybe we could come, you give me a few names you like, give me a few names you like. Oh look, we both pick the same. Like let's get this going. Let's set this up. Let's tee this up if it's going to happen anyway. Being able to report to the court, being able to recommend a 7:30 eval, I've often had judges run with that, like, great, you recommended it, let's do it, So some options to sort of move a case forward if I believe that that is in the best interest of those conservative.
Quick question. What's the interplay between a GAL and a court investigator
That's what I was going to say.
regarding investigation and providing reports to the court?
Okay. You could expand that to the interplay between a court-appointed attorney as well, or any of the parties. Court investigators' position is we try to remain as neutral as possible. We even try to distance ourselves to some extent from the judge in that process so that we can provide the most neutral representation that we can. When I go into a case like this, I'm looking at it like, okay, so my first job in all these is I'm answering two questions. Is a conservatorship necessary? And if so, is the person petitioning appropriate? So as to the interplay, I really try not to interact unless I need something from one of the attorney or the guardian ad litem specifically, also so that it doesn't affect their reports. So we all come in with our own views, and I think that allows the judge a better opportunity to take those if they're separate and see where there are similarities and differences and help them make their decision. In this, I'm going to start by gathering information. It's a familiar pattern. What I try to tell the newer investigators, you have to be really careful about starting to draw conclusions either from the information you have or an interview you get. Because I've had an interview, so I'm like, I know what this is going to happen. If you're going down here, I talk to somebody else or I pick up a report from somewhere else. Now I'm going this way. And so you just have to keep an open mind initially. I like to try to find neutral parties. News reports in here. So there was a police report in here. That's something I'm going to look for because the police officer has no reason to side one way or the other, and some of the issues that were up weren't even necessarily there. I'm going to go back before. I'm going to probably start with Dora just because she has knowledge prior to. I'm going to try to figure out what was going on up to the point that that's passed, and I'm going to try to get that information on the medical as well, just to see where Dora was, Gladys was at the time she was diagnosed. Was it really like what tests were used? Because a lot of doctors will use the mini multi-state. That goes to memory. It doesn't go to judgment. So I've had cases where they say, oh, this person is great. They scored 28 out of 30. And then I may have administered the Montreal cognitive, which includes judgment, and they scored 14 out of 30. So just looking at those, trying to find this a little more neutral, just fill up all of those. And I didn't pretty much everybody, because everybody's got their side of what's going on.
Yeah, and let me follow up on that also. The probate court's a protected court. And so that's why we're getting as much information as we can from different sources, because it's a living human. And I don't know if everybody does. I think most judges do. I'm trying to find the human being underneath all this stuff. And when I was guarding the Litem even, I find that anecdotal information is the best way to find out about someone, not necessarily directly the legal issues that are performed, giving them background, who they are. I remember one case, old lady, classic case where property rich, cash poor, and she needs cash at this stage of her life because she's getting up there in age. And her son wanted to just refinance the property, rent it out, and get a little few $1,000s a month of income as opposed to just liquidating the house and getting that. She's not the house. And objectively, right, to sell the house, give it money. But she mentioned something that it was a big deal for her family to actually buy these properties. I mean, she didn't even know what day of the week it was, she didn't know what month it was, but you said some value that she had in it. And so I think that's the important thing is when you're regarding Litem, for example, is find out who this person is, what their values are. Don't import your own subjective values on what best interest is. Let them speak to you. And just find some anecdotal information. And then I remember I said, objectively, we should sell the house. But she expressed to me a value in owning property. That was important for her and her family. And the judge let the son refinance. I would have done it. I think objectively it's probably the wisest thing. But I like to say that when I was guarding Litem, I let the answer reveal itself. And only a couple times did I have to make a call or punt it to the judge, say, I don't know. But a lot of times it's there. You just got to find the human being underneath. And so look for that. And again, look for anecdotal information, background, who they are, where they come from, what they. It's not like that you like to walk in the woods. It's when you get out of walking in the woods, then you find value in that. And that tells you something about the person and how their brain operates and what their values are. Because what do we need them for? I mean, yeah, you can still drop into bed, put in YouTube, I'm alive. That's been a living. And so you're looking what makes this person life is valuable. That's what you look at. And that's what we're trying to hopefully support.
So I'm going to jump and ask about trial. I don't know, first, I guess the first question is, with this framework, do you see cases about capacity and conservatorship in trial? And then when you are in that scenario, what is the various roles of people? Is the guardian ad litem going to be a witness on the stand, or is it going to be cross-examining? I've had judges do it differently, or what the expectation is, and it's really confusing. And then what if you've got court-appointed counsel who's trying to weigh in, because they've been involved in the case for a long time, weigh in on what the best interest is, because they have a really strong opinion about that. And their representation predates this change in the law. So all of that combined, can you address what trial looks like from each of your perspectives?
I'll go first. Once when I was guardian ad litem, I actually testified. It was actually an adult child support. The adult was, anyway, he's like crazy wealthy family, but like mentally disabled, and we were just going for adult child support under family code 3910. And they were trying to ask me what he needs. And that's kind of what I mentioned about like walking in the woods, is what we need is ultimately what we think our life should be like, what we're used to, what we grew up with. Because he grew up in a wealthy family, his idea of what life is was much larger than mine, and he was grew up that way. That's just normal for him. And so the lawyer trying to minimize support was saying, what does he really need? Well, this is what he grew up with. This is what his life, he views his life should be, and that's what he expects. But usually, I've also had guardian ad litem. I don't have my guardian ad litem testify for the most part. I just have them report what they think they believe the evidence shows. I disagree with them at times, because it's not their call. But I want to hear what they think the evidence shows. But that's what I'm looking for. Just it's a report to the court. They're there. They can ask questions. They're parties, technically. They can, in theory, resolve the case without the consent of their ward. Yeah, so usually I'll have them report it to me, what they see, what they think the findings are. But I would not have my guardian ad litem. But I have testified. So it does happen.
I have not testified. I have not had the pleasure at this point. Though who knows what the future will hold. One thing I wanted to address that we haven't talked about yet is the odd requests I've received as a guardian ad litem from counsel. I think sometimes in my role as a guardian, or in an attorney's role.
You can't leave.
They locked me. I'll get strange requests. Recently in a case there was a dispute, sale of a house, who was going to hold the funds. Someone called me, I'm the GAL, and said, can you put the $500,000 in your client trust account? And I'm like, no. No, I can't. I don't have a client. This is not my client's money. I think attorneys get very confused by the role that a GAL plays.
They're not allowed to manage money.
Right. I'm like,
They're
God, no.
legal rights.
And if I were to even attempt to do something a little wonky, it would be only upon a petition to the court and express, et cetera, et cetera.
And I can consent both parties and that's for corporate.
Yeah, exactly. So, you get these strange requests, and I find myself continually repeating to counsel, like, look, this is not my client. I do not have a client. Or I get requests to do work that arguably the other attorney should be doing. I get emails saying, you should do this, or you should do that. Ooh, don't tell me what to do. I don't like that.
They can petition the court to direct you.
Right. But I'll say, you're counsel. Like what are you doing? So I've had some interesting, and it's all, nothing's upsetting, or you get these odd requests flashed to you, and you have to constantly remind yourself about the lane you're in and what your role is. And so that's always an effort for me with I get some weird wonky request and I'm like, wow, where did that come from?
Yeah, it's a weird role. I mean, if you had a client, it would be the court, if you had a client.
Well, and caveat to that is we end up sort of a similar situation every now and then, particularly with the Court Appointed Counsel. They will contact us and they will want us to run criminal background check. They will want to get copies of police reports that we've obtained and such. And it's not that we don't want people to have the information, but there are regulations that prohibit us from giving that information directly to anybody. We are allowed to synthesize it, put it in our report, and then that's what the parties will get is our report when it comes out. Very open though, if as an attorney you have a concern about somebody, you say, yeah, I have this concern, I want you to know about it, and be assured, if we look at that and we think that's a concern or an issue that we need to address, we will address it.
I have a question about that. So let's say we're talking about an APS report, because you get APS reports. Guardian ad litem is the client, maybe the court. Does the guardian ad litem have a right to APS reports?
Not the copy that we have. They'd have to go to APS.
And they're not going to be able to get them from APS directly, that's my experience. So that seems to be a missing link to me. If I'm guardian ad litem, how do I get that piece of information? I don't want to know that. I'm trying to figure out what the best interest is, but there's no way to do that. Have you seen that come up at all?
I don't think I've had anybody ask me for an APS report. And we get them a little bit less now because APS now, if they come into a case and they find out the person is a conservatee, they just ship it to us directly. They don't even do an investigation. They go, oh. And rightly so, because they can only offer voluntary services, and if this person's a conservatee, they've already been deemed to lack capacity to accept those services.
Do court investigators automatically do a search for APS reports, or is that something that just
if it's indicated? So it's not like automatic out of every case, but if anybody, there's any kind of testimony that indicates that APS may have been involved, then yes, I will go and I will make a request to them for a history on the person.
So, moving on to settlements, what's the guardian ad litem's role in mediation? Because they're not a party, or they are a party, it depends on how you look at it, but do they have any signing authority or any role in guiding how a mediation should go? Should they be present in a mediation?
I want Christina there.
Yeah. So that's actually a gray area. I would want my guardian ad litem there. I would want them to sign on, but they don't have to. They're technically not a party, a litigant. And I probably would want to report if I was the judge in that matter, as far as the guardian ad litem's position in settlement. But I'd also want them to be hands-on. If it's a family, figuring out how they're going to operate. Who am I the judge? Who is the guardian ad litem the judge? How are they going to work it out? But having an objective third eye is probably helpful for everybody. Settlements are like prenuptial agreements. It's not what happens when things are great, what happens when things break down. That's what you're looking for in settlement. Having an objective third party work through that with you, I think is worthwhile. I would want my guardian ad litem there, but it's not required at any mediation settlement. I want them on board.
I generally, first, I do pay attention to, is it a case that can even, how's mama going to get paid? Meaning like, is it a case where, they're practically illiquid, they can't, they don't, so I mean, I pay attention, first of all, to sort of that, and I'm mindful, because often that's a huge concern on the part of a settlor or someone. So, also tease out, well, do you all want me there, or do even some of you want me there? But generally, I do participate. I will sign a settlement approved as to form. I won't, often they'll list me, that's another issue, often they'll list me as a party, And I'm like, oh, gotta change that, not a party. Often I will participate, and I think I do participate as more than a neutral if I do have a strong feeling as to what is in the best interest of the proposed conservatee. Sometimes it's in a trust matter, there is not a conservatorship. I feel like I have a little more leeway there. I generally do participate, and as Ms. Epstein can attest, I'm often pretty involved and active as a GAL litigation.
So what if there's a trust matter that's a companion case to a conservatorship case? And this will be my last question, and we can move on to the next hypothetical. What is the role of Court Appointed Counsel in conservatorship regarding when there's this whole other case out there that's all similar issues, but the guardian ad litem is not necessarily appointed, and the trust matter has the conservatee as the beneficiary of that trust? Does the Court Appointed Counsel have a role in that trust matter?
So let me tell you my thoughts about that. Is I want my guardian ad litem to look at it holistically. Like if there's other legal claims out there, point them out. You don't have to advocate. Say, I'm going to pursue what I want to pursue. I'll point out that there's other legal issues there, other legal rights that our proposed conservatee or conservatee may have. Because that's part of the context of understanding what's really going on. Sometimes, as we all know, these conservatorship proceedings are proxies for other issues that are going on. And so identify these other issues, identify legal claims that may exist in these other issues. I think that'd be really helpful. What if I answer your question?
Well, is there a way that a judge could or should pull in a guardian ad litem into the trust matter, or assign?
For example, that's when I appointed you to file for conservatorship. It was not only, don't remember the context, but I said we need this to happen in order for that to happen. So yeah, I can sui sponte do a lot of things when I've got an incompetent person, and I can direct my guardian ad litem to do certain things that need to happen. Because it's a protective proceeding. I've got a charge to make sure within reason that the best interest of this person is being served, period.
I've had a situation, one recently, where I'm Court Appointed Counsel and then was instructed to file something in the trust matter. And then, so this becomes a crazy thing where now all of a sudden I'm doing best interests in trust matter, but advocacy, zealous advocacy in the conservatorship matter, it seemed really inconsistent. And yet, if I wasn't in there in the trust matter, there would be nobody represented.
Oh yeah, no, so back when I was practicing, I was appointed guardian ad litem in a dependency proceeding because this person who was in the foster care system had a trust. Mom had just gone with all the money. So they actually hired, I got a specific order to file a case in another, in Orange County, which is where the trust was to try to grab the money and bring it back in and remove the mom. And so yeah, we can do that. I mean, it's technically, the guardian ad litem is by each case number. But I got a specific order to initiate a new case in another county to serve the interest of my ward. That was one of the few cases where there was a perfect case.
But that says guardian ad litem.
Yeah.
Would it be appropriate for a Court Appointed Counsel to be involved in the trust matter?
I think, no, I think that's what the guardian ad litem is for. Your lane is your lane. And then point out that, hey, they've got legal claims here, they got legal claims here, that's what the guardian ad litem should be doing. And we need to pursue those. So yeah, go for it. But I think your charge as Court Appointed Counsel is just to parrot. You're a megaphone for what the client wants. That's all you are as a lawyer. You're not there to, hopefully give wise counsel.
So if I'm going deep into my own case. If I'm
We're talking about the case.
a Court Appointed Counsel and there is no guardian ad litem, and it's the guardian. Okay, so that's my question.
But can you ask for one? Because isn't that tacitly admitting that your client lacks capacity?
Listen, capacity is just, one, can you feed yourself, can you clothe yourself, can you manage a basic checkbook, whatever. But the fact that we all have our blind spots. It's got a blind spot about this one legal issue, and we want someone to handle it. Or maybe they just, I had one case, guardian ad litem. This older woman, her daughter, one of two kids, said all her money was gambling, she wanted her money back. But they appointed me guardian ad litem because they weren't sure of capacity. She wanted her money back because she couldn't quantify it. So that's what I was like, yeah, she wants money back, but where do you draw the line? So I was there to draw the line as far as what getting her money back meant. So yeah, there's times when she has capacity up to a point. So maybe you are tacitly acknowledging, but listen, I've got my blind spots too. She had her blind spot as far as quantifying how much money was taken. That's okay. Or maybe she doesn't want to impair the parent-child relationship without guardian ad litem. Just a lot of it, that's you being creative as a lawyer to explain, oh, well, we just want to have a good relationship between mother and daughter, and so we want the guardian ad litem to pursue this, so she can be the mom. Frame anyway, that's good, be a good lawyer, right?
I think in Contra Costa, we really have to try to educate the court about the demarcation between best interest and zealous advocacy. And I almost think that because I've seen this happen over and over again, that the bench will appoint like court-appointed counsel to act as a GAL in a trust matter. I think maybe we need to, if the court asks us to step up in a role, we need to say, Your Honor, that's a conflict. Because it is. Like the roles are so clear now, but I see the courts kind of still leaning on court-appointed counsel to argue best interest when doing so would be really in contravention of their duties as LSAT.
Yeah, and let me just say this, is I like the clarification that these laws have, well, just being a zealous advocate. Trust the process. The adversarial process pulls out the issues and really exposes what's at issue. And then just trust that your judicial officer will see that and either make the correct ruling or appoint a guardian ad litem and help make that correct ruling. But, trust the process. You say that.
I had another situation that's arisen for me recently as a GAL. There's, of
Are you talking
course,
about your cases too now?
yeah, a little therapy session here. There's an emphasis on a conservatee or a proposed conservatee, let's say, correction. A proposed conservatee being able to hire their own counsel. So then I get appointed as a GAL.
A lot of issues with it.
Yeah, exactly. So I go in as a GAL. So, do you have an attorney? No. I've never had an attorney. I don't know what whatever they tell me. So I'm like, whoa, so I have an attorney telling me that they have been retained, and yet I am doubting as a GAL whether the proposed conservatee has the contractual capacity to hire an attorney because they don't remember they hired one. They don't remember they have one. Do you have anything an attorney gave you? I'll ask, do you have any paperwork? Did you sign any? Nope, haven't signed a damn thing. And it's like, I get damn a lot. I haven't signed a damn thing. and no, and so I'll get into the conversation. And what I do, and I've learned to do as a GAL with people with maybe diminished capacity, is circle back or catch them on a different day because you might get a good day and a bad day or a good moment and a bad moment. So I'll circle back and then I'm like, So do I report to the court? Like, do I really want, in Alameda County, for instance, legal assistance for seniors on board and counsel from LAS? Because I have sincere doubts that the attorney on board, and then when I talk to sometimes I'll talk to the attorney and they're like, oh, fine, I'm out. I'm out. They don't want to get too involved with it often at that point. But it's a sticky area, an area where I, as a GAL now, tread lightly, but I do inquire because I want to know if they have legal representation, and do I contact the legal representation first and say, hey, I'd like to speak with your client, and generally I get to do so without them present. Sometimes they want to be present. I mean, it's a gray area, but it's an area where I do push a little because I want to have some confidence that there's some knowledge and understanding that they have hired their own legal counsel. Because often it's a family member that's taken them to somebody and said, here's your lawyer,
So, we haven't really talked about it, but the concept of court-appointed counsel is really nuanced. And that's the harder one. Because if they come in with a lawyer, do I appoint the lawyer who will write that lawyer? I've done it a couple in which this lawyer was retained. If the lawyer has been retained by the alleged undue influencer and has just one phone call with the client, now you're out, court appointed. But if they've hired even one of the Heisler's hired a real estate lawyer, as long as you've done it, you've met with the person face-to-face, confidential communications, signed your retainer agreement, that's your right. Again, we've got the guardian and other tools, but where we draw the line as far as accepting a lawyer who comes in and overriding that, we have overridden it a couple times. Appointed counsel, that's tough. But it's all context specific. So like kind of what you said, what are the circumstances of the hiring? How did you find this person? Have they known you confidentially, privately, face to face, because you don't know what's happening off screen in the Zoom meeting or whatever. Those are all important circumstances to determine whether this is a true, free, voluntary hiring.
We have a question.
I have a question regarding cases where you're court appointed as counsel and you can't communicate with your client. So they're nonverbal, and this happens often in limited conservatorships. Is it appropriate at that point on an ex parte basis to petition the court to transition your role to a GAL, because you can't establish a relationship with the client, you can't advocate because they're not telling you to do anything. It just feels uncomfortable under these new laws to write a report as court appointed counsel saying, well, I didn't get anything out of my client, I interviewed them, they didn't acknowledge me, didn't speak to me, but I think this conservatorship should be granted. It feels weird.
Yeah, that happens all the time, especially with limiteds.
Right.
Severely autistic, nonverbal, whatever. Sometimes they won't even meet with you because they're so
Right.
compromised. I think you just report that, trust the process.
As court appointed.
Yeah, but we all want the best for our clients or wards, and so I think if you see something that's concerning, you can maybe say GAL might be appropriate. Just do some winks and nods, but I think stay within your lane. Support, hey, they were nonverbal. I reviewed the report. It looks like there's clear evidence of whatever findings need to be made, but it's a very limited appointment ultimately. And that's okay. I think if you have concerns, though, just try to think of nuanced ways to do your duty, but raise the issue, let the court pick it up.
I want to jump in there and say one thing, and I know there's a question. In recent cases I've had where the person is nonverbal, I am very cautious now because of the zealous advocacy requirements. I do not want to be written up in someone's held opinion, so I will report to the court, and I think the court understands. I will say I met or attempted to meet, I will say that, with my client, and he did not state an opinion. That's my response. He did not state an opinion. She did not state an opinion. Now, I'm not saying she said meek, or she's nonverbal, or she was strapped to a bed. I don't say anything. I just say she did not state an opinion. Did not state an opinion.
Yeah, I like that.
And then the judge is like, I wonder why. Maybe
Well, no,
GAL should.
but there's a court investigator report that I can
exactly.
figure out like how
Yeah.
or why they didn't state an opinion.
Right.
Maybe they don't have an opinion, maybe they can't state an opinion. There'll
Right.
be enough information from other
Right.
sources.
That's where this guy
Yeah,
comes
exactly.
in.
And that's one of our advantages. Our advantage is best interest, and I don't have this history, but don't advocate for anybody. Most times, trying to put the neutral facts out there, we do make a recommendation also.
You guys go into the home, right?
Oh, yes, always.
Yeah.
You have to meet with them.
Yeah, I think that's really valuable. In fact, when I was guarding Litem, I like to meet in their home, find out what their living situation is. Always. Also unannounced. Almost always unannounced.
Yeah, that one's a little difficult with developmentally disabled because most of them are living at home with their parents. But it's also straightforward. It's just an extension of their childhood. They're taking care of them. There's no CFS type actions and things. No reason to think they're not going to continue to take care of them.
Yeah, piggybacking off the last question, you have a conservatorship, the conservatee is nonverbal, pretty old, you can tell memory issues, but you can also tell that there are going to be issues coming up with family members. This isn't going to end soon. Is it the court appointed counsel's
duty to submit an ex parte for a guardian ad litem because you can't ever get an answer. A substituted judgment, selling properties, anything that's going to come down the line, or is that the court, or is that the conservator's position? Because you can't just advocate something.
Again, I think a lawyer is just a megaphone for their client. Whatever that client wants and says, you're supposed to articulate that in the most persuasive way possible. But again, we all are human. We all should be caring about our clients and their best interest. So I think, again, all you can do is like nod and wink or work the other parties to get them to follow suit and agree with these things.
I think in a
If someone is
situation,
just completely nonverbal, you're just not getting, you
Yeah,
have a
so-
90-year-old client that's all.
So for example, I think you could talk best interest to counsel for the daughter or the son or whatever. But to the court, you've got to be consistent, 100%, or articulate what your client wants. But I think behind the scenes, you can do a lot of good.
And I think too, my personal take in looking through some of these cases with this, for instance, you mentioned a substituted judgment petition. Often a substituted judgment, unless it's in a super high end state where you're trying to do tax planning, create a foundation, it's going to go via the rules of the laws of intestate succession. Is it cheaper to do a substituted judgment petition, have a GAL appointed to opine as to the best interest of the conservatee, go through all this rigmarole, and then have it basically go 50-50 to son and daughter via the laws of intestate succession in a trust? To me, it's like often six of one, half a dozen of another. So unless, that's a whole other discussion. That's not even a topic today, but that's like, unless you got a lot to do, it might be better to just leave it alone.
Thinking we should move to the next hypothetical.
I think so.
and by the way, it's no accident that a lot of these, in the hypotheticals, they're all women, because I think that we tend to conserve women more. So that's why all our hypos are Connie and Gladys. Yeah. Anyway,
Well, and men die too to write 7 8 years.
there you go.
They live long enough.
That's why those ads for those elder care places, like, a place for mom.
Yeah.
And I'm like, what about dad? And it's like, no, dad's dead.
Mom murdered dad.
Do you want me to read it?
Do you want me to read it?
Okay, second one. Connie Conservatee is 92 years old, has 2 children, Bob Bossy and Louise Leach. Connie is showing signs of moderate dementia that has never been diagnosed. Connie lives in her own home with Louise, Louise, who is providing caregiving services to Connie, including food prep and driving. Bob lives out of state. Connie has an estate plan that names Louise as the agent under the DPA healthcare directive, also executor and trustee. Connie's house is in the trust with an equity line. Bob found out that Louise has put herself on Connie's accounts and believes she is using Connie's money to feed her gambling habit. Bob retains counsel to petition for conservatorship with Fred Fiduciary appointed as conservator of the person's estate, alleging undue influence and incapacity. The court grants temporary conservatorship and appoints Angela attorney as counsel for Connie. Connie is outraged. She cuts off all communications with Bob. She adamantly denies having any incapacity issues and contends she's perfectly capable of managing her own health and financial decisions. She trusts Louise completely. She's hired her own attorney, a friend of Louise's that does real estate law, who is also helping Louise. So I think that means that is Louise's attorney as well. Connie does not want to meet with Angela attorney. She refuses to get a medical examination. Louise files an objection to the conservatorship. So this to me is something about undue influence and the relationship between that undue influence of potentially the daughter, Louise, and what is the court appointed counsel's role in navigating or suborning potential undue influence if that attorney who's been, or the court's issue with this. So if the attorney that Louise, that the mom wants, if that's a person who is siding with Louise, what do the various parties do to deal with that undue influence potential?
So we have some questions. They want to, how do you, Scott, see your role as court investigator in this case?
No, unfortunately, my role remains pretty consistent. But in looking at my first question, is conservatorship necessary? We are also required to look at what is the least invasive alternative. So here we have an estate plan. So I'm going to start there. We have an estate plan. We start something that's what Gladys won. This is what she put in place. So I need to establish that there's something wrong with this plan. That is actual undue influence that she's being used financially. So that's where I'm going to start. I'm going to start with the brother, Bob, and see what information he can give me. You know, is he just think, a lot of times you just, well, I just think they're doing that. Well, what do you have that makes you think this? And this is one of the areas in which we are able to get, I mean, out of almost any information, obviously not attorney-client privilege or work product, like financial records that I want. I can get all the health records I want, but we're not entitled to the financial records, so I can't just go into a bank and say, hey, give me that. So if Bob thinks there's something going on, then I would have to request that from the person who has control of that. That is where he feels there's an issue. And we may, it's convoluted and a large enough state recommend that the CPA, but an accountant come in and review that and see if there is hidden movements. But usually they're pretty obvious, and such.
Does the court investigator ever ask for records directly from institutions from a bank?
We don't ask them from the bank. We don't ask it directly to the bank to provide it to us.
I've been running into trouble with someone's been temporarily conserved, temporary conservator or temporary trustee seeks financing records. The bank says, no, you're not the owner of the account, you're not the conserved person. But the conserved person can't access it because they're conserved. And so there's just like, who can get it? And it's the answer seems to be just a subpoena, but it seems a little bit.
That's it.
Yeah, exactly. That's what
Subpoenas
I'm
are-
saying.
I always like subpoena better than even discovery, because you get it straight from the horse's mouth, and you can develop your own accounting, as opposed to relying on their accounting, their characterization of transactions.
And that's one of the things you have to point out. Sometimes we run into that same problem. We don't get it. That may be a point where I contact Court Appointed Counsel and I say, okay, I can't do subpoenas. I mean, I guess I could. It's not our rule to set up a subpoena. And I can't get these financial records. I need them. You're fine. Someone has the authority to get this. So, subpoena may be necessary, but I would let them know that I would like to have these documents.
Sorry, follow up. Do you ever, if the records don't come in, do you recommend to the court, I need to get these records before I can finalize my recommendation?
Absolutely. If I have anything, any information that's out there that I can obtain, it's just a matter I haven't been able to obtain it yet for one reason or another. And sometimes it's even agency reports, getting something from the DOJ or Children and Family Services. It's going to get here, it's just going to take some time. And if it's going to affect it, I can't really make a recommendation without that information. And yes, I will request a continuance for that.
Thank you.
Yeah.
And let me just follow up. There's only one tool to figure out what's going on financially, that's an accounting, period. You're going to have to do accounting. If you're a fiduciary, you're going to have to do accounting. Or we're going to, the only way to find out if there's anything nefarious going on is by an accountant. It's the principal tool. I can't think of any other tool. No one's going to admit that they're taking money for gambling, so it's accounting.
And if there's a power, if the daughter's the power of attorney, you can require that
Yep.
the attorney draft account.
Yes.
There's a petition for that. So people get really, I'm like, hey, do a petition, get the attorney back to account.
Yeah, or trustee. The trust waives it, but that's my only tool to find out, open up the hood, see what's going on. Period.
Right.
And they should want to if they're doing everything correct. Okay, look, I'm doing everything correct. Now, any my fees for doing the counting.
It's usually a sign that if people are really pushing back on that, that's like an initial red flag for me as a GAL. And I'm like, ooh, you know, I want someone to just, typically, as a GAL, I get the binder, you know, or the Dropbox or whatever it is, and, you know, that I can go through. Sometimes, as a GAL, I have, if a case has very little funds and the cost to prepare and accounting, I will personally go through and like look at, you know, basically create my own accounting, which is not fun, but done it.
Yeah, and just an FYI, I'm not perfect with my own personal accounts. I'm not expecting perfection, but just nothing gross, no gross malfeasance, and then we're good. But a lot of times one malfeasance leads to the next, and you've got patterns and substantial losses.
So I have a question about court appointed counsel and zealous advocacy. I can think of 2 times where ethically I would have an issue with doing the zealous advocacy. One is if my client wants me to do something that is going to hurt them financially because it's really expensive and there's now 5 attorneys at the trial, and you want to do something that the likelihood of success is very little. So if it's not in their best interest and you know ethically there's no likelihood of success. So in those instances, what are you supposed to do? So if your client wants you to, is telling you on the one hand, I want to save money. I'm broke, I don't want to spend any money at all in this day, but I want you to fight every fight. I am dead set opposed to all this. I need you to file X and Y and Z. And then Z is something that you know you're going to lose on. So you've got 6068, Business and Professional Code 6068, that says you're supposed to zealously advocate, and it also says you're not supposed to be filing with something that you don't believe in. As court appointed counsel, what do you do with that?
That's the art of the process. So instead of doing a 10-page objection, to do a 1-page objection.
But you're still doing the objection, and everybody's still going to hear.
Yeah, I mean, do the best job you can, but don't spend a lot of time on it. It's a loser. Or if it's a affirmative petition, do the best job you can, but be efficient, throw it out there. And then you can come back and say, look, I told you you're going to lose. You need to listen to me.
And you can still advise your client.
Yeah.
Yeah, we're a counselor at law, right? We're an attorney and a counselor
Yeah.
at law, so we need to counsel our clients.
In fact, probably my 2 biggest regrets when I did something that I really didn't want to do, my client was pushing me to do it. And I didn't push back. My old boss used to say, don't let your clients practice law through your license. So you got to be careful, for sure. But, you know, when they're compromised, you also need to establish that rapport and trust. So just go for it. It's not super onerous. Just file something, lose or win. See what happens.
My old boss used to say, we do crazy.
That's right. We do crazy.
I'm sort of curious what the panel thinks about, in this hypothetical, we have a private professional fiduciary who's currently in charge because there is a T-plan in place. And it may be going away because there's an estate plan and there's an objector and there are all these people. But what do you think the fiduciary should be doing? Because I hear often fiduciaries saying, I'm neutral, I want to stay neutral. But is the conservator's job a protective one? And I'm just curious what you all think.
So let me tell you my thoughts. And this is actually Mr. Talbot's case.
Better pay attention.
Anyway, there's a woman out on the Central Valley. We had a temporary conservator, Alquist, and he allowed the temporary conservator to live in an environment that wasn't the healthiest for her. And one of the arguments was, well, she's not being moved, therefore it's good for her. But Probate Code Section 2252 says that temporary only has as much power as necessary. And so I think I used the Lucky Charms example. Like, yes, she's not going to die today, so it's not like an immediate health and safety issue. But yeah, that doesn't mean that the environment's good for that person. And so, but the temporary should be just health and safety. That's all, like bare minimum health and safety until they're permanently appointed. then at that point, they can roll up their sleeves and use their full powers to put them in the best situation. But if the house is burning down, you know, in the case in the criminal department where the son was cleaning the house with gasoline, you know, that's when you take the person out of the home. But if it's just isolation, but they're being fed, being cared for, you know, let the process take care of it. But yeah, it's, again, temporary is not permanent. And so, like, one of the questions here is, did they file a substitute judgment? I don't like my fiduciaries doing substitute judgment, especially in temporary. Like, no, you're just there to hold the court down. And I like substitute judgment only as part of a settlement, that we're all coming together and, you know, restructuring things. And that's kind of like what you said before. It's going to go anyway. Why are we doing this? Yeah, just a temporary should just be immediate health and safety needs, like just make sure there's no immediate harm. But that doesn't mean they agree with the situation.
My only concern with the temporary is I've had some year and a half long temporaries where it's litigated and things get continued, and then I'll just do a special petition and at least, you know, it's expensive, but I'll put it in front, I'm like, go back to the judge, go back to the judge. Like, look, this is the situation, Your Honor, we've been at this 8 months, we're still in a temporary, these are the concerns. But if I'm representing a conservator, you know, I'm always thinking
you
best
need
interest.
you need to cover your conservator's back.
Right.
Make sure that they're not.
Right,
allowing
so my concern is like, if my client, who's arguably generally a professional fiduciary, is coming to me with some concerns or telling me this is what I really think needs to happen, this is in the best interest of the conservatee, temporary, if it's a lengthy temporary or not, or even if it's just a temporary, but something huge, I've had a fire, you know, move out, you know, petition to the court, we're not staying there, different things happen, so, you know, ultimately it's just really a judgment call.
I have a question about the role of the GAL in this type of situation, which I don't do conservatorship, so I do a lot of planning, which I see a lot of diminished capacity, and the role of the GAL in which we have some diminished capacity, but still sufficient, in which she might be knowingly allowing her daughter to take money for gambling, and saying, well, yeah, she takes care of me, she's living with me, she's my caregiver, and I want this, I'm okay with this. And if we were in a court setting, I would say, okay, well, we have to at some point honor her wishes and listen to what the client wants. But then if we have a GAL in which the GAL is, well, this isn't in her best interest, that her daughter's taking her money and using it for gambling. And so I guess I see this all the time, not outside of the court setting. And I'm kind of the only one there with the family dealing with these situations. And so I guess I'm just curious on what the GAL's role would be in saying, like, Your Honor, I think it's not in the client's best interest that her daughter be spending her money, but she has sufficient capacity at this point to say she's okay with it.
Are you saying as a planner, is there ever a time when you would have the input of a guardian ad litem?
I guess there's just like this tension because you guys are seeing it play out in the court setting in which you have all these different roles in which the GAL can say, it's not in the best interest that the daughter's using this money to gamble. But then on the planning side, we have the same situation in which the person has sufficient capacity to make a bad decision. And we have to honor the client's decision to potentially, in my mind, to make a bad decision. And so I guess I'm curious in the role of the GAL in the court setting of what position the GAL would take there, in which the GAL would even say, like,
well, I mean, in the court setting, I mean, you're not in the court setting. In the court setting, I'm going to report to the court if it's my professional opinion based on my investigation and my interviews that the frail elderly woman is too scared to bite the hand that feeds her because the gambler daughter is still lovingly taking care of her mother but just has a nasty gambling habit. I'm going to, and I can tell from looking at the accounts that, you know, an extra 10 or 20 grand is going out every month, whatever it is, I'm going to report that to the court. I mean, I'm ultimately going to go back to the court with it. As an estate planner, you have a whole other, when I do planning, people ask you to do certain things, you're like, I'm going to get deposed. If I put this on the page, I can see it. And it's often the cases like this fact pattern where there's like The daughter is home, lovingly taking care, and the two other siblings are in New Hampshire, and hasn't seen mom in 12 years, but they can't believe that, mom would have changed her estate plan to give it just to daughter who is, taking care of mom for the last 12 years and lovingly, blah, blah, blah. So it's always a shocker, but when you do it, you're like, oh. So, often I will, as a planner, this is a different discussion, CYA, cover my own ass. I'm like, would you like to go get a little evaluation? I think you'd be right, because you don't want litigation, because it may end up in litigation. I'll give my own advice to my client about you're teeing this up for a fight, So maybe you want to do this in a cleaner way, because if we tee this up, let's do it with the neuropsych eval from Dr. Kianik in the file, or let's do it with this or that. So to make litigation a tougher road to hoe down the line. Because people do make decisions or will nix one kid out or another, and it's often the caregiver kid that's shocked, I've taken care of mom for the last decade, they've never been here, and then they end up in litigation and they're appalled, but it's normal.
Yeah, those are tough cases, I'll say that.
Yeah, I just feel like.
I can see both sides.
Yeah.
There's sometimes situations in which I feel like in the court setting, the client's not allowed to make a bad decision, but still theirs. Whereas on the planning side, I'm able to allow clients with a certificate of independent review or a neuropsych exam to continue making the decision that I personally feel is bad, but it's still nonetheless their decision.
Well, I don't think that's 100% accurate, at least from our point. When I look at it, this game as a case, because that's one thing I sometimes I tell you, you can make bad decisions. It's the question is, do they have the ability to make that bad decision? And this is a very difficult case because it's not based on memory or anything obvious, and it may or may not be that this daughter she just has loving and this is her reward for taking care of her, or maybe she is afraid and this is more of an undue influence. But you get to one. I think the most extreme case I had was a lottery scam, and I'm literally sitting there talking about this person can take care of themselves, all the personal hygiene, get dressed, shopping, fix everything, pay their bills, nothing out of the ordinary. Except when they're standing out in the driveway and they're talking to the neighbor waiting for the editor to bring them Mercedes Benz that they just won the lottery. And the guy never shows.
I've got batteries on this skin case.
But when I stand there,
Hey,
this one's so extreme. It's literally, he's screaming, I'm running. You understand, there's no money. This is a scam. The person just went, yeah, I understand. Is this going to finish yourself, Christian? Because I have to go meet this guy. So that's when you know you need an evaluation. You need something more professional come in to let you know, is this a judgment? You should get it from cortex history here and judgment.
Yeah, all of our blind spots, for sure.
Oh, there's a question. I just think that as planners, you're speaking them a few times, guardian ad litems and conservatorships can go on for a really long time, but you don't really know in a planning perspective that it really is, the decision is there, right? You meet with them a few times, talk to them about it. Their capacity is a really complex issue. Undue influence is a really complex issue. We don't necessarily know that the decision is theirs just from a few meetings with them. And if you objectively think it would be a bad decision, after a few meetings with them, I would say do encourage them to do their own second balance. You don't really know that the decision is theirs. And in a conservatorship, a very long process, right? And so we do have more opportunities to kind of see where their capacity is.
Yeah, and just as that, I had a trial on that basic same scenario exactly, and it came out during testimony that the daughter was with her mom. Every time somebody came out, the daughter would reframe it in estate plan and stuff like that. So she raised the issue, not mom. She kept raising the issue. And so you don't know that as a planner. You don't know what happens on the drive to your office or anything like that. So you just have to be really careful. Those are tough, but yeah, she's absolutely coaching them.
I think in the planning context, the few times I've had situations like Christina was describing where, daughter's taking care of mom and the other kids suck and they live across the country and they never check in on her. At that point, if mom is adamant, and I kind of do feel like it makes sense, I would recommend to maybe pay the daughter for her time now.
Yeah.
If she is working for you, there's no reason to skew it later. Or sit down with all the kids and explain. And I'm like, invite your other children to the table. And I'm like, we can do it here. I can mediate it. But I feel like planners don't take it far enough sometimes because they don't do anything beyond what's in that first or second meeting, and I think you could be a way better planner if you actually deal with the issue before they die.
Yeah, I would follow up on that, like the anecdotal evidence I mentioned before, like how has the relationship with the other kids changed? If it hasn't, then why are you making this change? Stuff like that. So there's other points of reference you can make without hearing directly from what they're saying. Explore other things. You know your son's going to be hurt. You're preferencing one or the other. And like I said, quantify it. Like what is the word?
Like rewarding,
Yeah.
the loser kid is so dependent, but then the successful kid, like, there's no sense in like, not rewarding the successful kid, right?
They always do.
So there's that idea, but I think just inviting the kids to the table is such a tool that is available to planners that is not being used.
Yeah.
It's a tool, but I've often had clients go, yep, not gonna happen, not gonna do that.
Well, if you're not gonna wanna do that, then you're essentially admitting that you're opening up a big fight once you're gone.
Yeah, because
But they're like, but I'll be gone.
Yeah.
We'll make money.
But like, don't make me hold bomb for you,
Yeah.
You'll be gone, we'll still all be sitting here.
Yeah.
Mom told all the kids about the estate plan, and then to the amendments, you only told the daughter who benefited. Like, those are like the details that matter. Like, is this really, again, the pattern that you had, have you been open to your whole family when you made these decisions, and now you're not? Like, those will tell you what's really going on.
Time. Time.
We're an hour and a half, right?
Yeah, I don't think it goes until,
Till 11:30?
yeah, it goes until 11.
It's 11. All right.
Okay, guys, thank you.
Thank you.